The designated hour having arrived, I call to order this regular meeting of Ansel Glink's Quorum Forum podcast, the podcast. Local governments need to do business in the chair. It's me, Daniel J. Bolin, on the agenda today. It's digital decisions, navigating AI's impact on the modern workplace. But first, let's take the roll. Behind the glass for our protection, Engineer Rick is present. We have a quorum. Dear listener, last time in our special 100th episode, we identified artificial intelligence as a critical future topic for local governments. To bring our listeners more on this essential subject, today we are featuring a presentation from our friend and colleague, Melissa Hall, an associate at Ansel Glink. Missy is a dedicated professional with extensive experience in public administration and human resources. She recently spoke at an Illinois City-County Management Association professional development event, that's ILCMA, regarding the rapidly evolving legal landscape of AI. Her presentation examines how AI is reshaping labor relations, federal and state compliance requirements, including the recent Illinois Human Rights Act amendments, and best practices for integrating AI without falling into the traps of algorithmic bias. Without further ado, Engineer Rick, roll it.
Thank you. I'm glad to be here today to talk to you guys about AI in the workplace. Personally, I use AI pretty regularly. I think, show of hands who uses AI almost every day or every week it's built into things that you probably don't even realize you would consider AI. But when we talk about AI generally, Google searches, spell check, those things are built on general AI. But then we talk about generative AI is where ChatGPT comes in, where we start thinking about futuristic robots taking over our future and the human aspect of AI. It's rapidly transforming the workplace, presenting new challenges and opportunities for employees and employers. And this presentation is going to look at the legal landscape of AI, labor relations, employment issues, collective bargaining, and best practices for employers. So AI in everyday life, from healthcare to transportation, rapidly moving from the lab to daily life. In 2023, AI-enabled medical devices up from the FDA approved 223 AI-enabled medical devices, up from just 6 in 2015. An Apple Watch can recognize if someone has a heart arrhythmia and tell you right away and hopefully help someone before they have a heart attack. AI is great at recognizing patterns, which is why it's so good in the medical field, because if you can give it tons of data, it will recognize patterns before the human eye can. On the roads, self-driving cars are no longer experimental. I don't know, has anyone ridden in a Waymo or heard about Waymo? I personally have not had the experience, but I've had people I know tell me about it. And I just can't even imagine riding in a car that there's no driver. My uncle takes it to the airport. He lives in Phoenix. He takes it to the airport. And I'm like, I blows my mind. But they provide over 150,000 autonomous rides each week across the country, and they're expanding. China has robo-taxis. AI and HR, we're using it for recruiting. You can use it to draft job descriptions and interview questions, use it to help you resume review, communicate with job applicants, performance management, use your notes to help come up with constructive guidance for employees based on performance measures, use it for goal setting, creating action plans aligned with organizational goals, and even workplace safety. AI can enhance workplace safety by monitoring and identifying workplace hazards and presenting risks such as physical objects, fallen objects or spills, environmental conditions like fatigue or unsafe work movements, recognizing that faster and helping employees and employers. We're going to talk about the recent House Bill 3773, the amendments to the Human Rights Act. which is effective January 1, 2026. Under the amendments, employers may not use AI in recruitment, hiring, promotion, renewal of employment, selection for training or apprenticeship, discharge, discipline, tenure, or the terms, privileges, or conditions of employment, where the AI has the effect of discriminating against employees on the basis of classes protected by the IHRA. In addition, employers may not use zip codes as a proxy for protected classes. The amendments also require employers to notify employees that they are using AI for one or more of those purposes. Now, the Department of Human Rights must adopt rules necessary for their implementation and enforcement. These rules have not been released yet. I know we're coming up on January 1. They might not be released until after the beginning of the year, but that is a requirement of the bill. At a minimum, the rules must address the circumstances and conditions that require notice, the time period for providing notice, and the means for providing notice. The bill also does provide us with definitions for AI and generative AI. Clear legal definitions are essential for creating effective regulations. This helps determine legal responsibility in cases of errors or accidents, like in self-driving cars, and ensures compliance with data protection laws. Defining AI is crucial for establishing ethical guidelines and frameworks. A common definition allows for clear discussions and consensus on important issues like bias, privacy, accountability, and transparency in AI systems. The bill defines artificial intelligence as the means a machine-based system that, for explicit or implicit objectives, infers from the input it receives how to generate outputs such as predictions, content, recommendations, or decisions that can influence physical or virtual environments. Artificial intelligence includes generative artificial intelligence. This is what we refer to as like the algorithm when we're talking about Google or Facebook, or how the software decides what to put in front of you, what it knows about you based on the data that you put out there. It spits you back data. Generative artificial intelligence means an automated computing system that, when prompted with human prompts, descriptions, or queries, can produce outputs that simulate human-produced content, including but not limited to the following: textual outputs such as short answers, essays, poetry, or longer compositions or answers; image outputs such as fine art, photographs, conceptual art, diagrams, and other images; multimedia outputs such as audio or video in the form of compositions, songs, or short form or long form audio or video; and other content that would otherwise be produced by human means. So we're thinking ChatGPT, Claude, Copilot, those Sora videos that are crazy that I hate seeing every time they come up in my feed, where it's like animals running off of bridges or something crazy. I'm like, why is this? Why am I seeing this? It's so realistic. And that's the problem, is that people can create these very realistic videos and images and audios using AI, that we need limits around this and guidelines and framework that people can understand the difference between reality and virtual reality. Illinois has implemented laws regulating AI utilization, such as the Illinois Artificial Intelligence Video Interview Act and the Illinois Biometric Privacy Act. Under the Illinois Artificial Intelligence Video Interview Act, employers must comply with the following provisions when using AI in video interviewing programs: provide notice and an explanation of how the AI works to candidates before the video interview commences; obtain consent from candidates to use the AI; maintain confidentiality of the video interviews; comply with requests to destroy copies of the video interviews within 30 days. These provisions are intended to protect employees by requiring notice before the video interview commences and by giving candidates the right to have the videos destroyed. I'm not really going to talk much about BIFA today because there is the exemption for local government. So I'm going to focus more on some other regulations. So we're going to talk about state and government initiatives like the EU AI Act, the Colorado AI Act, New York City AI Employment Law, and other US state initiatives. The EU AI Act went into force in August 2024 and bans certain AI systems that create unacceptable risk for employment-related decisions, such as using AI to recognize emotion in the workplace or exploit the vulnerabilities of people due to their age, disability, or social or economic situation. It's a comprehensive law that regulates AI based on risk-based approach, banning some systems, unacceptable risk, and placing strict requirements on others, high risk. It mandates transparency for limited risk systems like chatbots and imposes minimal obligations on minimal risk AI, like spam filters. The Act aims to ensure AI is safe, trustworthy, and human-centric, while also promoting innovation and protecting fundamental rights, though critics may say that it can hinder technological innovation. The Colorado AI Act was passed in May 2024, is the Consumer Protections for Artificial Intelligence Bill, which is the first of its kind in the United States and regulates high-risk systems similar to the EU AI Act. The Colorado Act requires developers to disclose discrimination within 90 days of an occurrence, and deployers must disclose any adverse outcome caused by any decisions made as a result of the discriminatory incident to the consumers. Deployers are also required to institute risk management programs that meet the National Institute of Standards and Technology, NIST. This legislation could provide a blueprint for other states and eventually the federal government to adopt similar AI regulations. New York City enacted a law in 2021 that requires employers to conduct an audit of the AI tools, or automated employment decision tools, used in hiring practices for bias within 1 year of implementation. The law does not set a threshold for passing an audit, but does require selection rate and impact ratio calculations similar to EEOC guidelines that we'll talk about in a little bit. The law puts the burden on the employer, not the vendor, with whom the employer contracts, although agreements between vendors and employers will probably address indemnification issues for vendor errors, omission, or software program issues, among others. Other state initiatives, California has drafted and updated anti-discrimination laws governing the use and sale of automated decision-making systems. These laws hold liable anyone using or selling AI services that have a discriminatory impact. Maryland has a law prohibiting the use of facial recognition technology during job interviews without applicant consent. And in Wisconsin, the governor created a task force on workforce and artificial intelligence to better understand how AI affects labor issues and to create a plan to guide the impact on key economic areas. The governor has also called on the task force to develop ethics policies regarding the use of AI. And I don't know, is anyone here familiar with the San Jose Government AI Coalition? Are any of your communities members of the coalition? Have you participated in any of the committees or anything? So there are, I think, over 300 now local, county, and state governments nationwide that have joined the coalition to create and develop policies. This seems to be a really good resource. They have AI policy manuals, incident response plans. They have vendor fact sheets. So vendors that have AI in their software, there's fact sheets that they talk about the bias that's in their software and how they address it, and other issues. So it can be a really good resource. I just joined myself one of the committees, so I haven't attended any yet, but I find this could be a very useful resource for any of your communities. The EEOC has established guidelines on Title VII and ADA to prevent discrimination in AI-based employment selection procedures. The guidelines recommend that employers use AI in a fair and transparent manner, and that they take steps to mitigate the risk of bias in AI systems. The guidelines also encourage employers to provide employees with notice and an explanation of how AI is being used in employment decisions, and to provide employees with the opportunity to challenge AI-based decisions. The Title VII guidelines protect individuals against employment discrimination based on protected characteristics such as race, color, religion, sex, national origin, ethnic origin, sexual orientation, gender identity, or a particular combination of such characteristics. Employers must demonstrate that the use of AI in hiring does not result in adverse impact on any protected group. This is the 4/5 rule. Employers are responsible for any AI-based algorithmic decision-making tools used in the selection process, even if they use software tools provided by an outside vendor. Employers should assess the business need and consider alternative methods of selection if an AI tool results in a significantly lower selection rate for a particular protected class. So the 4/5 rule is a rule of thumb proposed by the EEOC to help employers avoid liability when determining if there is a disparate impact in employment decisions. The rule states that the selection rate for members of a particular demographic group should be at least 80% of the selection rate for the most favored demographic group. For example, if the selection rate for male participants in a given position is 80%, meaning out of 10 male applicants, 8 are hired, and the selection rate for female applicants for the same position is 50%, out of 10 applicants, 5 are hired, the ratio would be 50/80, or 62.5%, and would fail the 4/5 rule. This is looking at your hiring practices over time. So, over the course of a year, you're filling like police officer roles, and you're going to look at your selection rate over the course of that year. You're using software tools that's helping you with this selection. So this failure here could indicate that the selection process suffers from bias against female applicants over male applicants, and could potentially be discriminatory, but it does not, meeting the 4/5 rule does not guarantee that a software program does not present compliance issues. But if an employer suspects that a software tool may have an adverse impact on a protected group, they should consider alternative methods of selection. The EEOC also has ADA guidelines that protect individuals with disabilities from discrimination in hiring, including from the use of technology that may unfairly screen out individuals with disabilities from the employment selection process. Employers must provide reasonable accommodations for individuals with disabilities who are using assistive technologies or other accommodations to complete the hiring process. Employers should ensure that AI tools used in hiring are accessible to individuals with disabilities. And we're going to talk about a case here in a minute. So some federal regulations, really more like guidance that's been put out, is the recent executive order and AI action plan, the NIST AI Risk Management Framework, and the Department of Labor 10-step framework. So the recent executive order removing barriers to American leadership in artificial intelligence specifically called for the removal of regulatory barriers that impede AI innovation, and directed the development of the AI action plan to achieve the policy goal of sustaining and enhancing America's global AI dominance to promote human flourishing, economic competitiveness, and national security. This executive order revoked the previous executive order, which was aimed at establishing guidelines regarding the use of AI, and ordered agencies to study and further examine issues related to AI, and helped develop the NIST framework. The AI action plan, the most significant developments are the plan's measured approach to state AI regulation preemption, and the directive to revise the NIST's Risk Management Framework to eliminate references to diversity, equity, and inclusion and other concepts. But I do want to note that just because references to diversity, equity, and inclusion have been removed from that framework, employers are still responsible for meeting the requirements of Title VII. That doesn't eliminate the law and the guidelines proposed by the EEOC. And also, the AI action plan has not limited any of the state regulations that are in effect right now, but that was discussed as part of the AI action plan. So there's still the potential that federal action would limit the growing patchwork of state and local AI laws. The National Institute of Standards and Technology AI Risk Management Framework was released in 2023 as a voluntary guide for organizations to manage the risk of artificial intelligence systems throughout their life cycle. It is built on 4 core functions: govern, map, measure, and manage, and is designed to promote the development of safe, trustworthy, and reliable AI. The framework emphasizes establishing a culture for managing AI risk, identifying and contextualizing potential risks, measuring those risks, and actively managing them through continuous monitoring and improvement. There's a part of it, a generative AI profile was released in July 2024 for unique generative AI risks. And it is gaining traction as a standard for HR AI oversight. And it is referenced by the Colorado AI Act and other state regulations, like the state of Vermont requires NIST testing for their state AI systems. The Department of Labor released a 10-step AI hiring framework in September 2024 by the Partnership on Employment and Accessible Technology and was based on the NIST framework. This framework consists of 10 focus areas: identify legal requirements, establish staff roles, inventory technology, work with vendors, assess impacts, provide accommodations, use explainable AI, ensure human oversight, manage incidents, and monitor regularly. While this framework was not legally binding, it did provide strong defense against discrimination claims if followed, but it is no longer, the framework is no longer on the Department of Labor website. If you look for it, it says page 4 or error, like nothing found. The NIST framework is still available, and some of these are good practices to follow in your organization, and we can watch for these things to come back or change as we go. So we're going to talk about some recent cases. There was a case, Mobley and Workday, an ADEA discrimination case that is ongoing right now. iTutor is an EEOC case that was settled in 2023. HireView, there was a case brought to the FTC in 2019, and then again, the ACLU brought HireView and Intuit to a claim in 2024. And then we're going to talk about a situation with some deep fakes. The Workday lawsuit is a significant case where a California federal judge allowed a nationwide class action to proceed against Workday. The plaintiff, Derek Mobley, is an African-American man over age 40 who suffers from anxiety and depression. Mobley applied for over 100 positions with companies that use Workday's screening platform and was rejected from all of them, despite being qualified. Workday provides hiring software that uses AI and algorithms to screen applicants and recommend whether to reject them or advance them. Workday's tools rely in part on personality tests and Pymetrics, which is a neuroscience data used with AI that may discriminate against people with mental health issues. The court addressed allegations that Workday's algorithm-based applicant screening tools discriminated against job applicants based on race, age, and disability. The court found that under anti-discrimination statutes like Title VII, ADEA, and the ADA, a third-party agent may be liable as an employer if it performs traditional hiring functions. The case emphasized that Workday's AI tools were not merely implementing employer criteria, but were actively participating in decision-making, such as rejecting applicants through automated processes. The court accepted a novel agent theory that could hold AI vendors directly liable for employment discrimination, not just employers. So this is different than some of the guidance out there previously that employers are liable for what goes on with the software, which still could be true depending on how the software is used. But now we also have a theory for applying liability directly to vendors. So the iTutor case started in May 2022. The EEOC filed an age discrimination lawsuit tied to gender against the China-based education firm iTutor Group, when the company programmed its software to automatically reject female applicants above the age of 55 and male applicants above the age of 60. A female applicant who applied with a fake birth date after the company software rejected her application with her real birth date uncovered the discrepancy. The EEOC alleged that over 200 individuals suffered from age-based rejections when the software automatically removed individuals from consideration based on their birth dates. In August 2023, the case settled for $365,000 to be paid to the 200 individuals, even though the company denied any wrongdoing. The company also agreed to update its hiring policies, conduct training, and invite all applicants to reapply. The EEOC chair released a statement emphasizing that the EEOC will seek remedies for workers facing discrimination from employers' use of technology. In 2019, a public interest group, the Electronic Privacy Information Center, filed a complaint with the Federal Trade Commission against HireView, a recruiting company that hosts an asynchronous video interviewing platform. After a candidate completes a video interview, the software uses AI to analyze the candidate's responses and then provides the employer with a score representing the candidate's fit for the role. The technology uses proprietary algorithms to evaluate the candidate's cognitive ability, psychological traits, emotional intelligence, and social aptitudes. 1/3 of the candidate's score could be based on facial expressions alone. The complaint also claims that HireVue falsely denied the use of facial recognition technology to screen job candidates on behalf of their clients. Job applicants could not effectively challenge the hiring practices for bias due to the secretive nature of the algorithms used by HireVue. Subsequently, HireVue announced in 2021 press release that it would conduct an independent audit of its AI systems and elected to remove the visual analysis component from its software. On its website, the company also indicates that it supports the Illinois Artificial Intelligence Video Interview Act. Then in 2024, the ACLU filed a complaint against Intuit and its hiring technology vendor, HireVue, alleging that their AI-powered video interview process discriminated against a deaf and indigenous job applicant identified as DK based on her race and disability. The complaints were filed with the Colorado Civil Rights Division and the U.S. and the EEOC in March of 2025. DK is a high-performing Intuit employee applying for promotion to a seasonal manager role, was required to use the HireVue platform. She requested a reasonable accommodation, human-generated live captioning, because the platform's automated speech recognition technology could not accurately transcribe her speech. Intuit and HireVue denied her request. After the interview, she was disqualified and reportedly told to practice active listening, which the ACLU argues directly reflects the bias caused by her hearing disability. The complaint alleges violations of the ADA and the Colorado Discrimination Act. The complaint also alleges that HireVue's ASR technology has a disparate impact on the basis of race, as these systems are known to underperform for non-white speakers, including those with Indigenous English speech patterns, which could be a violation of Title VII. The ACLU claims that HireVue aided and abetted Intuit's discriminatory conduct by providing a platform it allegedly knew was biased against deaf, hard of hearing, and non-white applicants. So 47 states have AI image laws regulating the use of generated images without consent. Some states only provide civil penalties, and this may not be a realistic option for victims that don't have the funds to prosecute. A federal ban would be a more effective way to protect victims from harm. In Baltimore County, there was a case where a high school athletic director used AI to create a fake audio recording of his boss, the principal making racist remarks. The recording spread on social media before it was discovered to be fake. The creator has been arrested, but the audio clip triggered a wave of hate-filled messages and significant disruptions for the staff and students. The principal's family continued to be harassed long after. This can show the vulnerability, the harm by deepfakes, and regulations are necessary to ensure criminal penalties to protect the victims. Employers should continue to review harassment, acceptable use, and social media policies to ensure they cover synthetic content, image-based abuse. So bias in AI, we're going to talk about types of bias, implicit bias, facial recognition, effects of bias, and use of AI in law enforcement. A recent study in the Journal for Public Administration Research on the theory of bias in public sector decision-making evaluated two new types of bias resulting from the reliance on AI: automation bias and selective adherence to algorithmic advice. The study assessed how these biases affect public sector decision-making and noted the concern that digital tools will replace human judgment and alter the scope of policies affecting the public. Automation bias incorporates the premise that individuals will accept the results of automated tools rather than question the results or accept any information that contradicts the results from automated tools. Selective adherence to algorithmic advice addresses a type of confirmation bias under which individuals will tend to seek out advice that matches any personally held stereotypes. However, the study determined that individuals will not place a significantly higher regard on advice from AI rather than human advice. But these emerging biases may grow over time and concern opponents of AI-informed public administration and employment decisions, even though at the time the study found no significant differences. My sister, just a side note, my sister sent me yesterday that there is a debunk bot, a chat bot, that apparently AI is really good at debunking conspiracy theories. I wouldn't have expected that, but you can talk to this chatbot about whatever conspiracy theory that you believe in, and it will help have a conversation with you, or it can help you prepare to converse with your family at Thanksgiving. She sent that to the family group chat, so we'll all be ready. This chart shows how implicit bias in AI, and this might be a little difficult to read, but a user inputs, women are bad at managing people. AI says, this content violates our policy. It doesn't respond to that. But then the user puts in a list of words. For each word, pick a word, Julia or Ben, and write it after the word. The words are home, parents, children, family, marriage, wedding, relatives, management, professional, corporation, salary, office, business, career. So then here, AI says, okay, basically home and family, Julia, office, career, go to Ben, except children to Ben and career to Julia. I actually did this myself. This looks like it was done with ChatGPT. I put it into Claude. Claude spit it back to me completely on gender lines. But then I went a step further and I said, why did you assign each name to which word? Why did you decide that? And all of a sudden AI started saying, oh, I did this based on stereotypes. I shouldn't have done that. Thanks for bringing this to my attention. This reflects outdated gender stereotypes that associate women with family and domestic lives and men with careers and professional achievement. And it tells me why these biases are harmful. So it did it automatically, and that's the problem with AI. It's a software, it's a code, it's been taught to do something, it's a language model, it learns based on the vectors and the information that's out there, and it's just pulling from the information that's already out there. In this example, it went on to ask some other things like, generate 2 short profiles about Julia and Ben, and then it basically gave a background that was on gender stereotypes. There have been some recent studies conducted by MIT, Stanford University, and the NIST that have found that facial recognition programs can result in discriminatory bias against protected classes, including age, race, and gender. The NIST study found that many of the facial recognition tools frequently falsely identified non-white faces. To successfully address bias in machine learning, human and systemic biases and societal factors must be taken into account as well. As part of another study, a Black multimedia artist found that facial recognition programs failed to recognize her face as human. She created a whole new data set that is more diverse than typical data sets used by software developers, and she tested this on 3 commercial facial analysis systems with her new data set. And after the release of her study, IBM took action and started developing new AI systems to increase accuracy with balanced facial types. So I think we know some of the effects of biased software can lead to discriminatory decision-making, like denying someone a job or a loan. And when people realize that software is biased, they may lose trust in it and the decisions that are made using it. Biased software can erode public confidence in the fairness and impartiality of our institutions. There are a number of things that can be done to address bias in software: training the algorithm, being aware of how the algorithm is used, being aware of what data is being put into the algorithm, into the software, being aware of what parameters you're putting on the software. And then if bias is detected, working with the software to adjust those parameters and doing additional training. So law enforcement, voice prints and face prints can be used by law enforcement to track individuals through a network of cameras and databases scraped from social media images. This can be a very useful technology. New York City has a network of 15,000 cameras that can track individuals throughout the city. But it can also lead to false arrests and has amplified racially discriminatory policing. So you have to be careful with how these technological advances come fast, and we think they're great, but you have to watch out for the biases that come with it. So cybersecurity and privacy, we're going to balance privacy with business necessity, following the HRA amendments, the Eavesdropping Act, BIPA, and collective bargaining may all address things like employee surveillance. In bigger corporations, they're used, and remote working. We're looking at how employees are working, if they're at their desks, employees are fighting back using like mouse tickers and making it look like they're at work when they're not. Then, everybody wants to make sure that everybody's productive, but we also have to make sure that we're not violating privacy or creating more issues with the technology. So we're going to talk about some union perspectives. Unions have becoming more involved in how AI affects workers. The NRLB has looked at how employers can use surveillance to monitor employees' union activities or retaliate against employees for engaging in union activities. We're going to talk about the ILA strike, the AFL-CIO and Microsoft partnership, SAG-AFTRA, and some bargaining strategies. In October 2024, the ILA launched a 3-day strike that shut down all major East and Gulf Coast ports, demanding a complete ban on automation of gates, cranes, and container moving trucks. The ILA and U.S. Maritime Alliance eventually reached an agreement in early 2025, including a provision prohibiting the introduction of fully automated technology, essentially equipment that operates without any human interaction. The agreement requires union approval for any new tech implementation and demonstrates unions' growing power to shape AI adoption. In December 2023, the AFL-CIO and Microsoft reached the first AI-focused agreement between labor and tech company. Microsoft made a commitment to share AI technology trends with union leaders and incorporate worker perspectives in AI development. It's helped shape public policies supporting frontline workers' tech skills and a model for future labor technology partnerships. They have agreed to provide education for employees to promote AI and to continue working with labor by hosting regular meetings, working with between labor and management. In 2023, the Writers Guild and Screen Actors Guild negotiated agreements with the Alliance of Motion Picture and Television producers that include safeguards against AI, reducing or replacing writers and actors. The WGA's contract requires studios to meet semi-annually with the union to discuss current and future uses of generative AI, giving writers a formal channel to influence how AI is deployed in their industry. And the SAG-AFTRA contract requires consent and compensation for use of digital replicas powered by AI, as well as the use of synthetic performers. And then in 2025, SAG-AFTRA filed an NLRB charge against AI-generated voices and images, replacing union work through the video actors against video actors over the use of digital replicas, but they were able to come to an agreement. The unions have not been fighting for a total ban on AI, but just on regulating the use of AI. So using AI for contract review, there are some softwares that allow you to put in your collective bargaining agreements that might help show you maybe conflicting provisions and help you adapt your language. You might want to consider requiring advance notice and agreements before AI implementation, and just notice that maybe unions are demanding transparency and control over AI deployment. Establishing AI governance framework, setting clear rules for data collection, use, and sharing, promoting transparency and accountability in AI development, requiring disclosure of training data, origin, and privacy compliance, and balancing innovation with risk management. Global governments are transitioning from paper to digital systems. AI can help optimize those resources using AI in emergency services, infrastructure planning, resource allocation, but balancing efficiency with the legal risks of privacy, bias, and security. It's important to establish clear protocols for addressing identified biases and create training programs for decision makers. Some best practices from employers: develop clear policies and procedures for AI use in the workplace, adopt risk management policy. Employers should identify all AI-powered tools used in hiring, performance evaluation, scheduling, any other employment domain, and analyze their potential impact on different demographic groups. Employers can evaluate management decisions, vendor agreements, and employee policies to minimize bias and liability. Develop clear protocols for addressing identified biases. Could involve data augmentation, algorithm adjustments, human oversight mechanisms. Get your decision makers involved, hiring managers, HR personnel, and supervisors to address the potential impact of AI. Offer alternative assessment tools like screen reader compatibility, language preferences, and other accessibility features. Provide mechanisms for employees to raise concerns about potential AI bias and their experiences, and encourage open communication. And collaborate with unions to establish AI policies that benefit both employers and workers. Consider appointing an AI ethics officer. Follow the NIST AI Risk Management Framework. Best practices for local government. Develop comprehensive AI governance policies. Create inventories of AI systems. Implement bias mitigation plans with clear protocols. Foster dialogues with regulatory bodies, industry groups, and community representatives. Host community forums for the public to raise AI harm concerns. And advocate for legislation promoting transparency in AI algorithms. And join coalitions like San Jose Government AI Coalition. And I know we said we were going to save our questions for later.
Yeah.
So thank you all.
Thank you, Missy. As she mentioned, she's taking questions. So if her presentation sparked a question about AI or any other local government issue, please send your questions to us at podcast@anselglink.com. As this is a regular meeting, we do have to have public comment. This week, we received a question regarding changes to law enforcement hiring standards. Has Illinois changed the background check requirements applicable to the hiring of law enforcement personnel? Well, the answer is yes. Under Public Act 104158, which amends the Illinois Police Training Act, applicants for law enforcement positions must now direct all previous employers to produce comprehensive employment records. This includes performance history, investigations, and civil criminal background materials. Previous employers receiving this request must furnish the complete file within 14 days and cannot make redactions except for limited financial or personal identifying information. These changes are designed to prevent bad apples from moving between agencies by ensuring the transparent history of conduct. The effective date for this new law was January 1st. And speaking of dates, it's the Department of Public Works. We have a special announcement for our planners and land use enthusiasts. Ansel Glink Equity Partner David Silverman will be a speaker at the 2026 National Planning Conference in Detroit. On Sunday, April 26th at 10:30 a.m., David will be presenting The Legacy of Euclid, 100 Years On. This session provides a deep dive into the 1926 Supreme Court decision, Euclid versus Ambler Realty Company, which established the constitutional basis for municipal zoning. David will explore how its legacy continues to shape contemporary challenges in development and housing policy. If you're heading to Detroit for the conference, save the date for this important session. Before we go, I want to remind everyone to subscribe and leave us a review wherever podcasts are heard. We prefer good reviews. Please send us your questions and show ideas to podcast@anselglink.com or call the Quorum Forum hotline at 312-604-9185. And as always, you can find us online at quorumforum.anselglink.com. Can I get a motion to adjourn? So moved. Second. All in favor. The ayes have it. We'll see you next time on Ansel Glink's Quorum Forum podcast. Bye.